This is the plaintiff, Greg Travers. He says his lousy landlord, the defendant, refuses to return a security deposit due to the so-called cleaning fees he needed to get the apartment in shape after he moved out. The defendant thinks he can just skirt the law and do whatever he pleases and get away with it. But he's here to teach him a lesson and get the $595.50 he's owed. This is the defendant, Hugh Thresher. He says the apartment was certainly not cleaned to his satisfaction, and he has every legal right to withhold the guy's security. All his policies are clearly stated in the lease. He followed all the proper procedures, and he thinks the judge will agree. He's accused of keeping a tenant's money.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says his landlord hijacked his security for no good reason, but the defendant says both the plaintiff and the apartment were unclean. It's the case of Mr. Unclean.
Thank you, Douglas.
You're welcome,
Greg Travers, you are suing Hugh Thresher for $595.50 in security deposit plus interest plus lawyer's fees because according to you, he's wrongfully keeping, your former landlord is wrongfully keeping some of your security deposit. Talk to me. What happened?
Well, on December 1st, 2010, I moved in, and on April 30th, 2013, I vacated the apartment, and I waited until May 24th until Hugh sent part of my security deposit back.
Okay, and did you get that along with a letter?
I did.
Okay, do we have a copy of the letter?
I do.
All right. So what is the reason that you kept part of the security deposit? How much did you keep? $495.50?
Yes.
Why?
Essentially, the plaintiff signed a lease addendum in addition to the lease, which stipulated an agreed-upon amount, which would be go towards cleaning at the conclusion of the time that the tenant was there and when the tenant moved out.
Regardless of how clean the place is?
Yes.
Okay, what is this paragraph purporting to say? That it's $195 for carpet cleaning and $195 for cleaning?
Yes, it is.
If applicable.
Let's see. The tenant agrees to steam clean carpets if applicable upon departure and show receipt of payment confirming the carpet was cleaned. The tenant agrees to pay $195 for carpet cleaning if no receipt is provided to landlord. And you want me to interpret that to mean, if applicable, meaning if it's dirty. And I presume you want me to interpret that to mean, if applicable, meaning there's carpeting.
If there's carpeting, right.
Right?
Yeah.
Okay, so that's one disagreement that the two of you have. And you also did a little legal research into this, and
yes,
according to you, there's something you want to show me that says that he can't even put this in a lease.
Yes, ma'am. I went to a attorney and basically showed him the lease, and I just asked, is this legal? Can he do this? And
Well, what'd you think when you signed the thing? Just out of curiosity.
I didn't like it.
Didn't bother you until it actually applied?
I didn't like it, but I didn't really think I'd have trouble collecting my security deposit because in the past I never had problems.
Okay, but even if you had determined if applicable to mean if dirty, the second $195 in that clause basically says you're paying me $195 as an exit fee.
Right.
You know, it basically says that's what you're paying to clean the apartment. So that part, why didn't that part bother you when you signed it?
Well, it did, but I also found out from my attorney that there is a a case law act that the Attorney General said that you can't put a clause in a lease for a cleaning fee.
There is an opinion by the Attorney General back in 1980, which I'm going to look into now, that says that you can't deduct for cleaning if it was clean. Is there any question that it was clean? Like, in other words, are you actually saying that the place was dirty?
I'm not saying that it was dirty. I'm saying cleanliness is a personal taste
Right,
item.
but I just want to know if this is up for grabs in this case as well. Are you saying?
I'm saying the apartment does need to be cleaned. It needs to be freshened up. It needs to have Febreze put in the carpets.
Okay, do you have any pictures of problems of how he left it?
No, I don't. I just go in and I send in a cleaning crew to go in and clean, and there's
Okay. How did you do your calculations?
Okay, I took $195 for the,
Right.
to clean the apartment, $195 for a cleaning, steam carpet cleaning, and I think after 2.5 years of living in an apartment, I think it's reasonable to expect the carpet would have needed to be steam cleaned. And then I withheld a late fee for a payment that was made in February of 2013.
All right. And what is the late fee that you were charging?
It's a 10% late fee, $105.50.
And why were you late then?
Do you remember the blizzard we had?
No, baby, I live in Miami, Florida. Y'all were probably complaining about it to me on the telephone, but I was out there sunbathing and I couldn't really hear it over the. All right, yeah, I kind of do. But what happened?
In February, we got nailed with 3.5 feet of snow.
Right.
I sent an email to Hugh, just basically asking him, would it be okay to pay rent when I was able? There are roads like Main Streets that even haven't been plowed.
Right, but that means he's not responsible for that.
No, I'm not saying that,
Right.
but I had no way to pay rent. I had no way to get to the bank to pay rent.
You don't have a checkbook? Isn't that how you normally pay rent?
I write a check, I go to the bank, deposit in his account.
Okay.
But
Could you just mail it?
No, I go to the bank and I deposit it.
I know that's what you do, but couldn't you just this time mail it?
It was just a couple of days before the blizzard.
Okay. What did he respond to that email?
did.
And what did he say?
He just basically said, be safe, do your best, let me know when payment is made. So I believe that
Let me see the response. Okay. Your response is, thanks, be safe, and do the best you can. Please confirm payment when you can make it.
Mm-hmm.
So then why, when the guy moves out 2 or 3 months later, are you for the first time bringing up a late fee?
I'm not bringing it up the first time. The rent was due on the first.
I don't want to hear your argument. I want to hear why you're bringing it up now. You say it's not the first time. Have you brought it up before then? Because the response I see kind of leads him to believe like you're not going to be a jerk about it.
Well,
and, because it's a snowstorm and it's, 2 days and, it's
Right.
kind of, for you to bring it up for the first time, so correct me if I'm wrong when I say that, for you to insist on the late payment for the first time after the guy moves out 3 months later seems kind of, So did you bring it up in those 3 months?
No, he moved out 2 months later.
All right, court's in recess.
All rise.
Okay, so if applicable, does that mean if it's dirty or if there's carpeting? Somebody told me you're a lawyer. I have no idea what you're going to say. What do you think?
I think it's when it's dirty, because if applicable means there are times when it's not applicable, so it's pursued.
Well, it's not applicable when there's no carpet.
Well, true, but you wouldn't have to steam a carpet.
2 lawyers are never going to solve anything in this amount of time going inside the courtroom.
Thanks, guys. Have a seat, please.
Okay. Here's how I see it. Number one, I understand you went out and found a lawyer, and your lawyer sent a letter attaching an attorney general opinion, which is not binding on me, talking about how you can't charge a cleaning fee. I don't even know why the attorney general would get involved in that. Be that as it may, it's 30 years old, okay? And I have found nothing in the case law to reflect such a thing. And I'm sure your lawyer told you that as well. There is not a single case that says that you cannot charge a cleaning fee. That being the case, and case law is what binds me, I'm looking at this fresh. And the question I have in my mind is, when 2 grown people enter into an agreement, should I enforce it? And my inclination is yes. The agreement that you entered into was that the carpets, if applicable, and that doesn't mean the carpets if they're dirty. To me, that means the carpets if they're carpets. You will have to do that. So I find that the $390 is appropriate. I, however, do not find that the $105.50 is appropriate. Landlords have to be very careful, because if you have the right to enforce something and you don't, it might be considered waived. Now, every good lease has what's called an anti-waiver provision, and your lease has it, which says, don't assume because I don't charge you a late fee that I'm waiving it. I hereby reserve my right to charge you whatever, to enforce my rights, and my silence doesn't mean otherwise. So if there had just been silence, I wouldn't consider it waived. But I kind of feel that you were trying to be a nice guy about it and give him the other 48 hours, but I kind of feel that sending that email is an affirmative waiver, and I find that you cannot charge $105.50. So I am going to order you to pay to the plaintiff the amount of $105.50.
Thank you very much.
Hold on right there, please.
Well, first out of the courtroom is the defendant right here. What's your first take on this ruling?
I believe I won. I mean, I won there were three components of it. I won 2 out of the 3, and I think the third component, is it's unfortunate I didn't win that piece as well.
You realize you just should have kept your mouth. It would have been better for you.
Right. Yeah, absolutely. That's correct.
All right.
Thank you very much.
Right around this way. All right. So next out of here, the plaintiff. Let's find out if he's satisfied with what he got out of this. What are you?
Oh, well, for the most part, yes.
Yeah.
Yeah. I mean, it's not exactly how I wanted it to go, but I don't know the law, so that's why
Were you surprised to hear that the Attorney General got involved in some of these issues?
I was surprised that there is something that old on the books, yes.
Yeah. Harvey, what do you think?
Well, Kurt, actually, here's what I know. The person who drafts the contract has an ambiguity interpreted against him. So in this case, it's interpreted against the landlord. It means that only if the carpet is dirty.